state fined him for paving the access road to his farm, his own land, his own money, his own road. But watch the moment when the judge opens the property documents.
The road to my farm was dirt for 30 years. Every spring, mud up to the knees, equipment gets stuck. Last year, I paved it at my own expense, $18,000. The road is entirely on my land. From the gate to the farm goes nowhere else. A month later, a $3,800 fine arrived for unauthorized road work. I say, this is my land, my road, my money. They say a permit is required. Performing road and asphalt work requires obtaining a permit from the road department under Transportation Code Section 12-A. The plaintiff carried out paving without the appropriate approval. The nature of the work performed is classified as road construction. The $3,800 fine was issued lawfully regardless of the form of land ownership. I'm opening the property documents. The road begins on his land and ends on his land. Entirely. Not a single meter extends beyond the property boundary. I'm opening Transportation Code Section 12-A. A permit is required for work affecting public roads or public land. His road is neither. This is a private road on private land. This man at his own expense improved his own property without affecting any public territory. The $3,800 fine is dismissed. The state pays court costs.
Is fixing a neighbor's car a crime? The city said yes. The judge said not unless he got paid. Watch the ticket get torn up in 10 seconds.
Your Honor, sir, I'm not running a business. My neighbor, Miss McDavid, is a single mom. Her radiator blew. The dealership wanted $1,200. I told her to buy the part, and I put it in for her. I fixed it in my driveway for free. I didn't take a dime for the work.
Your Honor, we have photos of tools out, parts on the ground, and a vehicle registered to another address with its hood up. In our opinion, that is clear evidence of commercial vehicle work in a residential zone. And for that reason, we believe it's an unpermitted shop, Your Honor.
So you cited the gentleman for running a commercial enterprise. The legal definition of commerce requires trade for profit. Helping a neighbor is not a business, sir, unless you have a receipt showing he got paid, which you have not. This ticket is dismissed.
A retired Marine quietly filled 3 decorative stone bollards with concrete and bolted them into the ground outside his 83-year-old neighbor's front porch after a drunk driver nearly killed her sitting in her rocking chair. When a speeding pickup truck jumped the curb and hit all 3, the truck was totaled. The driver's family sued the Marine for $85,000. Watch the judge's reaction.
Your Honor, the defendant installed hidden reinforced barriers on a neighbor's property without permits, without disclosure, and without any warning signage. He created a concealed fixed hazard directly in the path of street traffic. Our client's truck sustained $85,000 in damages. This was not a garden decoration, it was a booby trap. We demand full restitution.
Your Honor, I did 22 years in the Marine Corps. 18 months ago, a drunk driver jumped that same curb in Miss Dorothy's rocking chair by 6 inches. She is 83 and she still sits on that porch every single evening. I installed 3 decorative bollards on her private property with her full permission. Was I supposed to wait for the next truck to come through her living room while she sat there?
He was drunk, jumped a curb, and totaled his truck on a flower decoration. You sued the Marine who put it there to protect an 83-year-old woman. Dismissed. Your client owes him $60,000. Get out of my courtroom.
A woman received hospital bills for treatments she never had. The hospital insisted the charges were correct. When the judge reviewed the records, everything changed.
Your Honor, I started receiving hospital bills for thousands of dollars. They listed tests and treatments I never received. I was never admitted, never treated. I called the billing department again and again, but they told me the charges were valid and sent the bills to collections anyway.
Your Honor, the charges were generated by our billing system. The patient name and date of birth matched our records. Insurance was billed automatically. When payment was not received, the account followed standard collection procedures.
The medical records clearly belong to another patient. This defendant was never treated at your facility. Continuing to bill her despite repeated notice is unacceptable. All charges are dismissed.
This nurse was fired for holding the hand of a dying patient. When the judge learned that the patient had no family, the entire courtroom fell silent. What happened in that final moment changed how everyone saw the case, and what the judge said next would leave the hospital speechless.
She kept saying she was scared. She begged me not to leave. She had no family, no one else there. So I stayed and held her hand while she passed. I wasn't thinking about rules, I was thinking about her. I was fired the next morning.
Your Honor, hospital staff are required to follow protocol at all times. Physical contact beyond what is medically necessary is strictly prohibited, and the nurse made a personal decision rather than a professional one.
What you call a violation looks a lot like compassion. This nurse did not abandon her duty, she fulfilled its most basic one. Comfort is not a breach. This termination is hereby overturned, effective immediately.